Hey, this is Sakshi Mishra. Welcome back in Judicial World. And heartily welcome to our audiobook series where we explore landmark legal cases that have shaped the landscape of Indian law. In this episode, we delve into the intriguing case of State of Punjab and others versus Davinder Singh and others. A case that questioned the principles of reservation and equality. This case, marked by complex legal arguments and significant social implications, culminated in a landmark judgment by the Supreme Court of India. So sit back and immerse yourself in the story of this pivotal legal battle. Let us talk about the genesis of the case. In the vibrant state of Punjab, known for its lush fields and bustling cities, an important legal battle was brewing. The state of Punjab, represented by its officials, was locked in a complex legal dispute with Davinder Singh and others. This was not just any ordinary case, it was a battle that would capture the nation's attention and set a precedent for future legal interpretations. The conflict begins. The state of Punjab had its own set of rules and regulations designed to maintain order and fairness. However, Davinder Singh, along with several others, felt these regulations were unjust and discriminatory. They believed the state's actions were not aligned with the principles of equality and justice enshrined in the Indian Constitution. What was the allegations? Davinder Singh and his companions alleged that the state of Punjab had violated their rights. They claimed the state's policies were discriminatory and targeted them unfairly. This was not a simple accusation. It was backed by a series of incidents and actions taken by the state that, according to the plaintiffs, clearly showed bias and injustice. Let's talk about the legal battle. The case made its way to the courts, where both sides presented their arguments. The state of Punjab, represented by its legal team, argued that their actions were within the legal framework and necessary for maintaining public order and welfare. On the other hand, Davinder Singh's legal team passionately argued about the principles of equality and non discrimination, citing various instances and legal precedents to bolster their case. Now the Supreme Court steps in. As the legal battle intensified, the case reached the Supreme Court of India. On 1st February 2024, the Supreme Court rescheduled the hearing to 6 February 2024. A seven-judge bench led by Chief Justice D.Y. Chandrachud was tasked with resolving this critical issue. For 3 days, the courtroom was filled with intense debates and discussion as both sides presented their arguments with fervor. What was the court's dilemma? The court was faced with a challenging task. It had to carefully consider the arguments from both sides, review the evidence, and interpret the law in a manner that upheld justice and fairness. After 3 days of rigorous hearing, the bench reserved its judgment, leaving the nation in anticipation. Let's talk about the verdict. On 1st August 2024, the Supreme Court delivered its much awaited verdict. In a landmark decision, the top court upheld the validity of subclassification within the scheduled caste and scheduled tribe categories. The judgment was delivered with majority, highlighting the complexity and significance of the issue at hand. The court recognized the need for subclassification to ensure equitable distribution of resources and opportunities among different groups within the scheduled castes and tribes. It emphasized that such measures were in line with the constitutional principles of equality and social justice. The aftermath, the decision of the Supreme Court was met with mixed reactions. For Davinder Singh and his companions, it was a moment of mixed emotions. While their concern about discrimination were acknowledged, the court's endorsement of subclassification brought a new dimension to the fight for equality. For the state of Punjab, the ruling was a validation of their policies and an affirmation on their efforts to achieve social justice. The judgment set a precedent for future cases, reinforcing the importance of nuanced and context specific approaches to achieving equality. It understood the need for continuous efforts to address historical injustice and ensure that the benefits of affirmative action reach the most marginalized section of society. What was the reflections of that case? The case of State of Punjab versus Davinder Singh is more than just a legal battle. It is a testament to the enduring principles of justice and equality that form the bedrock of the Indian Constitution. It serves as a reminder that in the quest for order and governance, the rights and dignity of individuals must never be compromised. As we reflect on this tale, we are reminded of the delicate balance that must be maintained in a democratic society. A balance where laws serve the people and justice is accessible to all. Let's see the journey to the verdict. To understand the significance of this case, we must delve into its intricate details and the journey that led to the landmark verdict. In 1975, the government of Punjab issued a notification dividing its existing 25% reservation for scheduled caste into two categories. Half of these seats reserved for the SC category were to be offered to Valmikis and Mazhabi Sikhs. The other half of the reserved seats was for the remaining groups within the SC category. This notification continued to remain in effect for 31 years until the Supreme Court's 5-judge bench decision in E.V. Chinnaiah versus State of Andhra Pradesh 2004 set aside a similar law in Andhra Pradesh. Since the SC's Chinnaiah decision ruled that subclassification within the SC category was not permitted, the Punjab and Haryana High Court struck down the Punjab notification on 25th July 2006. The SC decision in E.V. Chinnaiah can be divided into two key parts. First, that state governments cannot categorize any group of people as scheduled caste as per Article 341. This power solely belongs to the President. Second, that the scheduled caste category as a whole, as determined under Article 341, was one homogeneous group. This meant that any subclassification within a homogeneous group would result in persons from the same class being treated differently, thereby violating the right to equality. Following the Chinnaiah decision, the Punjab government passed the Punjab Scheduled Caste and Backward Classes Reservation in Service Act 2006. Section 4, subsection 5 of the Act reintroduced first preference reservation for the Balmikis and Mazhabi Sikhs. Half of the total seats reserved for the SC category would be offered first to these two communities before all other SC groups. On 29 March 2010, the Punjab and Haryana High Court struck down this provision of the Act based on the SC's decision in Chinnaiah, leading to a subsequent appeal to the Supreme Court. The Punjab government argued that E.V. Chinnaiah was not in accordance with the SC's 9-judge bench decision in Indra Sahni versus Union of India 1992. In Indra Sahni, the SC recognized that some classes within the other backward classes (OBC) category may be more or less backward than others. Accordingly, states were permitted under law to make sub-classification within the OBC category to address such differences. The Punjab government contended that E.V. Chinnaiah wrongly understood this to mean that only the OBC category could be sub-classified and not the SC category. On 20 August 2014, the 3-judge bench hearing the appeal referred the matter to a five-judge constitution bench to assess the correctness of E.V. Chinnaiah. On 15th July 2020, a five-judge bench led by Justice Arun Mishra and comprising Justice Indira Banerjee, Vineet Sharan, M.R. Shah and Aniruddh Bose began hearing the matter. The appellant's Punjab government pointed out that preferential treatment was a phase of the right to equality. Subclassification, as introduced by the Punjab government, was permitted by Article 16(4) and furthered the cause of adequate representation. Moreover, the SC's 2018 decision in Jarnail Singh versus Lakshmi Narayan Gupta permitted subclassification within the SC category by recognizing the creamy layer concept. The five-judge bench noted that subclassification was permitted for socially and educationally backward classes (SC/BCS) under Article 342A, introduced in 2018, which empowers the President to prepare a list of SC/BCS. It stated that the constitutional provision for recognizing scheduled caste, Article 341, scheduled tribes, Article 342, and SC/BCS, Article 342A, were pari materia, meaning on the same matter, and must therefore be interpreted similarly. Since subclassification was permitted within the SC/BC category per Indra Sahni, it cannot be disallowed for the scheduled caste and scheduled tribes categories. Further, the SC noted that as the state was competent to grant reservation for the SC and ST category under Article 15 and 16, it must also be permitted to introduce subclassification to give effect to the spirit of the right to equality. Since the appeal against E.V. Chinnaiah involved the interpretations of Article 14, 15, 16, 338, 341, 342 and 342A, it was a matter of immense public importance and therefore necessary to ensure that Indra Sahni and other precedents of the SC were correctly followed. Accordingly, the five-judge bench noted that it was not competent to revisit E.V. Chinnaiah, which was also heard by a five-judge bench. It referred the matter to a seven-judge bench on 28 August 2020. On 12th October 2023, the SC listed the appeal for hearings by a seven-judge bench from 17th January 2024. The case was expected to answer two primary questions. First, can subclassification be permitted for the SC and ST categories since the same is permitted for the SC/BC category? And second, are state legislature competent to introduce subclassification within the SC and ST categories? The final hearing and judgment. On 1st February 2024, the Supreme Court rescheduled the hearing to 6th February 2024. After 3 days of intense hearing, the seven-judge bench led by Chief Justice D.Y. Chandrachud reserved judgment in the case. Finally, on 1st August 2024, the top court upheld the validity of subclassification within the scheduled caste and scheduled tribes categories in majority decision. This landmark judgment was celebrated as a significant step towards achieving social justice and equality for all. Thank you so much for joining us on this journey through the corridors of justice. The tale of State of Punjab versus Davinder Singh is a powerful reminder of the enduring spirit of justice and the continuous effort to uphold the principles of equality and fairness. Until next time, stay curious and keep exploring the fascinating world of law and justice. Thank you.